All right. Good evening, folks. Well, already having issues with OBS on YouTube. We'll see. Let me know out there on YouTube if that's working all right. Welcome to Friday Night Fun Night on Kirk's Law Corner. Hope everybody had a wonderful week. And okay, should be good. I wonder if I just did a refresh on my end. I don't know why it's having a hard time on this other machine when it's more badass than the other one. Hey, Diesel D's and CC, how you guys doing? I don't know why. All right. Hopefully it still works out there on YouTube for you guys out there. We'll see. Why it's being a pain in the butt, I have no idea. But anywho's, um, all right. Thanks, James. Hi, Jacqueline. And of course, there's early birds out there. So I apologize for being a little late. I taking care of a puppy dog, and I got home a little after 7, and I'm like thinking there's something I'm missing here. And I looked at the clock, and I'm like, oh, that's right, Friday Night Fun Night. So forgive me for the delay here tonight. My fault. And yeah. So there's whoa, there was a little string of trolls that we had here the other day trying to claim that I should take down my USMC stuff here because I'm not a real Marine and stolen valor and all that stuff. So here we go. There's me, my grandfather, and I, Marine Corps. Yep. That'd be me in the Marine Corps. So that would make you all a liar. We'll just show a couple more pictures there. Oh, there's me and my grandmother. Yep, that'd be me in the Marine Corps. No, I dress blues. Yep. I don't know. I can't remember. I think this was my platoon. Yep. There's a bunch of us Marines there. It'd be kind of hard to be in these pictures if I wasn't in the Marine Corps, right? I'm looking for the one that was more of a updated one, but with my national defense ribbon. I know I've got that picture here somewhere. Desert Storm, Desert Shield there. Yeah. National defense ribbon. Now, I'm not claiming that I saw combat, but my unit was deployed over there. And really, they didn't really do a whole lot other than go over there and disable some tanks. And the only casualty we had was one of our own, which he had. They parked a little too close to the tank, and he stuck his head out of the top of the turret. Wanted to watch it shoot the tank, and a piece of shrapnel came back and took his head off. That was the only real casualty that we had over there. So for all you trolls out there who want to claim that I'm stolen valor and all that good crap, you can kick rocks. So just to clear the air there about me being in the Marine Corps or not. So say like this one. Marines have nothing to be proud of. Why wouldn't we have something to be proud of? Makes no sense. We all signed that blank check up to and including our given our life to defend, right? I mean, that's what we do. Every branch of military does that. When they take that oath to defend this nation, foreign and domestic enemies, we put our lives on the line. Now, I get that there's some other controversial stuff behind whether or not we're actually defending America or not, but that's aside from the point. You know, the Marines are the most badass trained people, the longest boot camp. And not only that, after I went through 13 and a half weeks of boot camp, had another 28 days of Marine combat training before I went to my school's battalion. So, yeah, I am for real. You know what? The clear distinction between the Marine Corps and all other services is what the Marines are actually trained to do. You know, I know this might be a little bit of a shocker for some people, but we're trained to kill people right out of boot camp, right in boot camp. Army doesn't do that. The Air Force doesn't do that. The Navy doesn't do that. You got to go to special training, you know, like Navy SEALs, which, you know, the Navy SEALs come and train with the Marines. So, um, you know, just saying, right? It should be a well-known fact that that's what Marines are trained to do in basic training. So fundamentally and principally, that's what they're trained to do. So, uh, yeah, farmer and a wrestler too. Did wrestling in junior high. Yeah, don't necessarily want to get into a argument about the Marine Corps or not, but you know, the fact is I did go in with the intent to serve, and I was awarded the National Defense Ribbon because I was in during time of service. So whether the trolls or anyone else out there likes that or not, that's irrelevant. That's the facts, and that's, you know, that's just the truth. So y'all can just kick rocks. Trolls, that is. I know. Kind of hard to believe, right? But here we are. And I stand true to my oath that I did take, which is to defend this nation called America. Not the United States. The nation is called America. The United States are all the states that united. Again, a union, a league of friendship, a confederacy. They're all synonymous. They all mean the same thing. So that's just the way it is. Right? Reading comments out here. So it is a life-changing decision. Yes, it is. And, you know, not all of it's bad. Here we got another one out here. Oh, why don't you address how you stole from Field McConnell and blamed everything on the task force and Timothy? Right. I stole from who? No. Another one of them deep stater trolls out there that's worried about what's coming their way. It's called disparaging. You're making false statements. Anybody else having problem on Facebook? Somebody's saying that they're just seeing a black screen. If you're having a problem on Facebook, you could just do a refresh, and see if that helps. And now all of a sudden my YouTube says, oh, now I've got an excellent connection. Now there's no problems. I guess it takes a little bit of warming up over there. Okay, so other people are saying they can see fine. And by the way, I'll give you a little update on Field. He's doing great. Back at home, relaxing, following the order of the court. But it seems to me that somebody's getting a little worried about what's about to happen and trying to make a resolution, trying to resolve and settle out of court or settle the court. So yeah, so there's some weird stuff going on there. Yeah, trolls. I know you're never really going to give up, at least until you're caught and removed from society as a whole. So your days are coming. And boy, there's some stuff going down right now. What does open court mean? That's a good question, actually. Supernova out here on YouTube. What does open court mean? Kind of funny because I actually have some stuff pulled up here talking about the court being open according to the act. So I'm going to get into that here in a little bit because it specifically states that the court is supposed to be open all the time. That's because when you make an arrest, you've got to take somebody before the nearest and most accessible magistrate. And if it's an arrest under a warrant, you got to take it before the man who issued the warrant, unless the warrant's being executed in a different county. You still got to take him before the nearest and most accessible magistrate. So, of course, more reading means reading, right? So, anyways, want to put the plug out there for support getting into this other building. Got about halfway there, about half of what I need to get in there. And I haven't received anything in the mail yet. I know the snail mail is a little bit slow. So Fix It Fast, he's putting the address and stuff out there on YouTube. But if you'd like to help support the cause and get us into a better building, be greatly appreciated, because it's going to open up to the ability to hold law seminars right out of my own building and not always looking around trying to find a building and cost money. And then I can actually start doing like my week-long classes that I'd like to do, educational, school. And I've already figured out approximately maximum capacity there, about 40 people with tables and chairs. So it gives you any kind of an idea how big the front room is. And of course, then there's the main office area, another small little office area, and a little kitchen area, and the bathroom. Bathroom is actually rather large. Could have made that a little bit smaller and gave us more secondary office space, but hey. Oh yeah. Bring that up. Put that right there. send those donations over to the office at this address here, 6477 West Fairview Avenue, Suite C, Boise, Idaho, 83704. Of course, don't forget the good old kirkslawcorner.com and Patreon. If you get on Patreon and do a monthly support through that way, that's great too. We'll get you into some access of other things going on, and private Wednesday night workshop. And of course, once I get this up and going, I will be sharing some of those classes to tier 3 and tier 4. So, and that's patreon.com/kirkslawcorner.com. I just want to thank everybody that has given their support and in the past. And I want to thank my team members, my go-getters, and then of course everybody behind the scenes team, those of you right here right now, and there's everybody else in support over there that helps make it all happen. Couldn't do all this without you. So we're going to have a little bit of fun, right? Show some conflicting things that are happening now that conflict with the real statutes now, mind you. Now this is again from the come on, mouse being funny here. Okay, so this is the from the first legislative session for the territory of Idaho. And I'm down to this section here. It's still in this section under the Civil Practice Act. And I found this little section here concerning courts of justice of this territory and judicial officers. The following shall be courts of justice of this territory. First, the Supreme Court. Second, the district courts. Third, the probate courts. And fourth, the justices' courts. So, okay. Now we're going to say that the judicial branch is courts of justice. I thought we established justice in the legislature, not the judicial. The judicial branch are supposed to be courts of law and courts of equity. But let's read and learn here a little bit of history, as this was in the first legislative session before the Constitution for the territory of Idaho was even created yet. See, this brings up the question of why are they making statutes, enactments of the legislature before the Constitution? In my mind, this is laying down the law before we institute government. Because technically speaking, we already have government with the Organic Act. But let's read on. The Supreme Court shall have appellate jurisdiction in all civil cases where the amount of dispute exceeds the value of $100, and all criminal cases tried in district courts, and shall hold its session at the Capitol at the times fixed by law. Wait a minute. The Supreme Court's supposed to be at the Capitol? Why do we have a separate building for the Supreme Court? District courts. The territory shall be divided into 3 judicial districts. Now, obviously, as we grew, districts grew per the Constitution. There shall be a district judge for each of the judicial districts. The courts held by them shall be the district courts of the territory. The jurisdiction of these courts shall be of 2 kinds. First, of original, second, of appellate. The district court shall have original jurisdiction in civil cases where the amount of dispute exceeds $100, and in all criminal cases not otherwise provided for. Remember, This is under the Civil Procedure Act. Huh. What's going on here? Civil Practice Act, pardon me. Provided the district court may enter judgment for a less sum than $100 upon the plaintiff's paying costs. The appellate jurisdiction of the court shall be extended to hearing on appeal. So the appellate courts, right, the courts of judges thereof, shall have power to issue all writs necessary or proper to the complete exercise of power conferred upon them by the Constitution and the Organic Act. Ooh, Organic Act. The terms shall be held at such times and places provided by law. If a room for holding the court be not provided by the county, together with attendance, fuel, lights, and stationery suitable and sufficient for the transaction of business, the court may direct the sheriff to provide such room. Attendance, fuel, lights, and stationery, and the expenses shall be at county charge. The district judges shall, at all reasonable times, when not engaged in holding courts, transact such business as their chambers, as may be done out of court at chambers. They may try and determine writs of mandamus, certioria, and quo warranto. Hear and dispose of all applications for orders and writs, which are usually granted in the first instance upon an ex parte application, and may in their discretion also hear applications to discharge such orders and writs. Whenever an action or proceeding is commenced in the district court in which the probate court has concurrent jurisdiction, the district court may, if the parties consent, by order, transfer the same to the probate court of the same county. Upon such transference, the probate court shall have an exercise over such action or proceeding in the same jurisdiction as if originally commenced therein. Each district court shall have the power to make rules not inconsistent with the Constitution and laws of the territory for its own government and the government of its officers, but such rules shall not be enforced until 30 days after their adoption or publication, and no rule shall be made imposing any tax or charge upon an illegal proceeding or making an allowance to any officer for services. Okay. Let's think about that for a minute. That means when you go for an appeal, right? Oh, I guess this is okay. We're talking about the district court. All right. Now I'm going to skip over the probate courts. Come on. Come on, mouse. Where are you? What is going on with my mouse here? All right, so now we're going to get into these justices' courts. The courts held by justice of the peace in this territory shall be denominated justices' courts and shall have the jurisdiction conferred by this act. But nothing contained in this act shall affect their jurisdiction and actions of proceedings now pending therein, nor shall it affect any judgment or order already made or proceedings already taken. Justices' courts shall have jurisdiction of the following actions and proceedings. First, of an action arising on contracts for the recovery of money only, if the sum claimed does not exceed $100. Second, of an action for damages for injury to the person, or for taking or detaining personal property, or for injuring real or personal property, if the damages claimed do not exceed $100. Third, of an action for a fine, penalty, or forfeiture not exceeding $100 given by statute or the ordinance of an incorporated city. Fourth, of an action upon a bond condition for the payment of money not exceeding $100 to the penalty, though the penalty exceed that sum, the judgment to be given for the sum actually due. When the payments are to be made by installments, an action may be brought for each installment as it becomes due. Fifth, of an action upon a surety bond or undertaken taken by them, though the penalty exceed if the amount claimed does not exceed $100. Sixth, of an action to a lien on real or personal property when the debt secured does not exceed. So we're looking at, $100 here as a max till we get down below here. Of an action to recover the possession of personal property when the value of such property does not exceed $100. Eighth, to take and enter judgment on the confession of a defendant when the amount confessed does not exceed $100. Ninth, of an action for foreseeable or unlawful entry upon or foreseeable or unlawful detention of lands, tenements, or other possessions. 10th, of an action to determine the right to a mining claim and for damages for injury to the same when the damages claimed do not exceed $100. 11th, of proceedings respecting vagrants and disorderly persons. The jurisdiction conferred by the last section shall not extend, however, to civil action in which the title of real property shall come in question. It's because there's land supposed to go under probate. These courts shall also have jurisdiction on the following public offenses. Now, wait a minute. Now we're talking the civil practice. So this is civil. These courts shall have jurisdiction over the following public offenses committed with the respective counties in which such courts are established. First, petty larceny. Second, assault and battery. Not charged to have been committed upon a public officer in the discharge of his duties or with intent to kill. Civil Practice Act. And we're talking about assault and battery. Huh. So what's really going on here? Third, breaches of the peace. Riots, the phrase, committing a willful injury to property, and all misdemeanors punishable by fine not exceeding $500 or imprisonment not exceeding 6 months or by both such fine and imprisonment. This is supposed to go under the Civil Practice Act. Yes, as I previously stated, Field is back home, enjoying his home. There shall be no terms in justices' courts. These courts shall be always open. So that answers your question about courts being open. Courts of justice are supposed to be open, always. Remember night court? Yeah. They're always supposed to be open. That's because if you make an arrest at night, you got to be able to take them before the nearest and most accessible magistrate. And then for misdemeanors, you're not supposed to be making arrests at night for misdemeanors. So, why is our courts not open? Why are people being taken to jail? Violation of due process of law, false imprisonment. Now, each justice, before entering upon the discharge of his duties, shall take the constitutional oath of office, not statutory, and shall execute a bond to the territory in the sum of $2,000, conditioned for the faithful performance of his duties, and file the same with the county clerk. So, general provisions respecting the courts of justice and judicial officers. The Supreme Court, the several district courts, and several probate courts of this territory shall be courts of record. Uh-oh. Sitting of every court of justice shall be public, except as in provided in the next section. All right. So this means the sittings of every court of justice shall be public, except as provided in the next section. In an action for divorce, the court may direct the trial of any issue of fact joined therein to be private, And upon such directions, all persons may be excluded except the officers of the court, the parties, their witnesses, and counsel. So, every court shall have power first to preserve and enforce order in its immediate presence, second, to enforce order in the proceedings before it, or before a person or persons empowered to conduct a judicial investigation under its authority, third, to compel obedience to its lawful judgments, orders, and process, and to the lawful orders of its judge out of court in an action or proceeding pending therein. Fourth, to control in furtherance of justice the conduct of its ministerial officers. So these are some limitations, right? Now, a judge shall not act as such in any of the following cases. First, in an action proceeding to which he is a party. I mean, that's just obvious. Or in which he is interested. Second, when he is related to either party by consanguinity or affinity within third degree. So no cousins, no aunts, no uncles, all of that stuff. Okay, so third, when he has been attorney or counsel for either party in the action or proceeding, but this section shall not apply to the arrangement of the calendar or the regulation of the order of business, right? A judge shall not act as attorney or counsel in a court in which he is a judge, or in an action or proceeding removed therefrom to another court for review. Cannot practice law from the bench. Or an action or proceeding from which an appeal may lie in his own court. Judge of the Supreme Court or the District Court shall not act as an attorney or counsel in any court, except in an action or proceeding to which he is a party on the record. A judge or justice of the peace shall not have a partner acting as an attorney or counsel in any court in this territory. So I wonder how many judges out there that have significant others that are attorneys. The courts of justice may be held and judicial business may be transacted on any day except provided in the next section. No court shall be open, nor shall any judicial business be transacted on Sunday, on New Year's Day, on the 4th of July, on Christmas Day, on Washington's birthday, on Thanksgiving Day, or on a day in which the general election is held, except for the following purposes. First, to give, upon their request, instructions to a jury, then deliberating on their verdict. Second, to receive a verdict or discharge a jury. Third, for the exercise of the powers of magistrate in a criminal action or in a proceeding of a criminal nature. That's right, because they have to be open. Always open. Provided that when the day fixed for opening a court shall fall on any of the days mentioned in this section, the court shall be opened on the next or succeeding day. Every court of justice except a justice's shall sit at the county seat of the county in which it is held, except in cases provided by law, approved December 18th, 1898. No justice of the peace shall hold a court at any other county or city than the one for which he shall have been elected. So clearly, these courts have got to be open no matter what under these instances. See, that third one there, for the exercise of the powers of a magistrate in a criminal action or in the proceeding of a criminal nature. Now, it does say, provided that when the day fixed for opening any court shall fall on any of the following days mentioned in this section, the court shall be opened on the next or succeeding day. Okay, with these exceptions, right? So basically, there has to be a magistrate on duty 24/7, 365 days a year for the exercise of the powers of a magistrate in a criminal action or in a proceeding of a criminal nature. That's so that we have access to justice 24/7, no matter what time of day it is. There's somebody supposed to be there that we can lay our complaints before him. Seems like the comments stopped out there, which is weird. Come on. Oh. All right. So let's see. Every court of justice except a justice shall sit at the. Okay, we already discovered that. Seals of the Court of Justice. Each of the following courts and no other shall have a seal. First, the Supreme Court, the district courts, and the probate courts. The clerk of each court shall keep the seal thereof. The seal of the court need not be affixed to any proceedings therein, except first to a summons or writ, second to the proof of a will, or the appointment of an executor, administrator, or guardian, third to the authentication of a copy of a record. So these courts of justices courts, they're not supposed to have a court seal. Or also there for purpose of evidence in another court. The seal may be affixed by impressing it on the paper or on a substance attached to the paper and capable of receiving the impression. Miscellaneous provisions respecting courts and judicial officers. If an application for an order made to a judge of a court in which the action or proceeding is pending be refused in whole or in part or be granted conditionally, no subsequent application for the same order shall be made to any other judge except of a higher court, provided that nothing in this section be so construed as to apply to motions refused for any informality in the papers or proceedings necessary to obtain an order. A violation of the last section may be punished as a contempt, and an order made contrary thereto may be revoked by the judge who made it or vacated by a judge of the court in which the action or proceeding is pending. Judges of the Supreme Court, the district courts, and the probate courts shall have power in any part of the territory, and justices of the peace within their respective counties shall have power to take and certify, first, the proof and acknowledgement of a conveyance of real property or any other written instrument. Second, the acknowledgement or satisfaction of a judgment of any court. Third, an affidavit to be used in any court of justice of this territory. No action or proceeding in a court of justice shall be affected by a vacancy in the office of all or any of the judges or by the failure of a term thereof. Now, every written proceeding in a court of justice in this territory or before a judicial officer shall be in the English language, but such abbreviations as are now commonly used in that language may be used, and numbers may be expressed by figures or numerals in the customary manner. This gets rid of the all capital letters stuff, because that's not proper English. That's not part of the English language. There it is. Now, there's a bunch of more stuff here. But that pretty much lays out the different parts, right? Should be 270. Might have to go down a little to get to the criminal. Now that we know that under the Civil Practice Act, that this stuff's supposed to be civil, right? Even assaults and batteries. So now that we see this, now when we get down to this Criminal Practice Act, now I want people to pay attention here. Here it is, Civil Practice Act from 1864, not 1881. This is in the first legislative session for the Territory of Idaho. Now, somebody had made a comment out there, oh, well, the CCP of 1881, no, that's the California Civil Procedure. No. What would California have any jurisdiction in Idaho? It wouldn't. And here is the act right here from 1864. I may just speed up here. I know it's got to be getting close. Right here. Now, to regulate proceedings in criminal cases in the courts of justice in the Territory of Idaho. Now, wait a minute. Why were they talking about criminal stuff in the Civil Procedure Act? Because let's read and comprehend. Crimes defined. Be it enacted by the Legislative Assembly of the Territory of Idaho as follows. A crime or public offense is an act or omission forbidden by law. This is that malum prohibitum. But in order to be the bylaws, you have to be bound by the Constitution first, which means you have to be a public servant in order to commit a public offense. This makes a lot more sense now. So, if a crime is actually a public offense, only public servants can commit crimes in a criminal court. But this is still saying in the courts of justice. Okay. Because see, watch. And to which is annexed on conviction, first, death, second, imprisonment, third, fine, fourth, removal from office. How are you going to remove somebody from office if they're not a public servant? Disqualification to hold or enjoy any office of honor, trust, or profit under this territory. Public offenses are divided into first, felonies, second, misdemeanors. Now remember, we can't have bills of attainder here. Not applying to the people. No bills of attainder. All right. So a felony is a public offense punishable with death or by imprisonment in the territorial prison. Every public offense is a misdemeanor. Now, look at what it says here. No person can be punished for a public offense except upon legal conviction in a court having jurisdiction. So, what's going on here? every public offense must be prosecuted by indictment, except, here's the exceptions. First, when proceedings are had for the removal of a civil officer of the territory. I'll be darned, we're under the Criminal Practice Act, and we're talking about the removal of a civil officer of the territory. Second, offenses arising in the militia when in actual service in time of war, or which this territory may keep with the consent of Congress in time of peace. Third, offenses tried in justices' courts. Okay. So which court's this going to be in? This would be the district court now, wouldn't it? But they're all courts of justices, right? So I guess a court of justice is not the same as a justice's court, which we previously covered there under civil. So the proceedings by which a party charged with a public offense is accused and brought to trial and punishment shall be known as a criminal action. A criminal action shall be prosecuted in the name of the people of the United States in the territory of Idaho as a party against the party charged with the offense. Party prosecuted in a criminal action is designated in this act as the defendant. In a criminal action, the defendant is entitled, first, to a speedy and public trial, second, to be allowed counsel, as in civil actions, or he may appear and defend in person or with counsel. So where does it say a member of the bar? Oh, that's right, because the bar wasn't created yet. The Idaho State Bar wasn't created yet in 1864. So how did we have attorneys and counselors prior to the Idaho State Bar being created? I'll be darned. But like it says, or he may appear and defend in person or with counsel. This goes back to right back to the fundamental principles that was laid down in 1776, that we all had the right to the assistance of counsel, that we had the right to appear in person and with counsel, and the right to be heard in person and by counsel. Somebody has fundamentally altered our form of government. That's a no-no. That would be treasonous now, wouldn't it? All right, so to be allowed counsel in the third, to produce witnesses on his behalf and to be confronted with the witnesses against him in the presence of the court, except that where the charge has been preliminarily examined before a committing magistrate and the testimony taken down in writing and subscribed by the witness in the presence of the defendant who has, either in person or by counsel, cross-examined or had an opportunity to cross-examine the witness, or where the testimony of the witness on the part of the people who is unable to give security for his appearance has been taken conditionally in the like manner in the presence of the defendant who has either in person or by counsel cross-examined or had an opportunity to cross-examine the witness. The deposition of such witness may be read upon it being satisfactorily shown to the court that he is dead or insane or cannot with due diligence be found within the territory. No person shall be subject to a second prosecution for a public offense for which he has once been prosecuted and duly convicted or acquitted. Bam. No person shall be compelled in a criminal action to be a witness against himself, nor shall a person charged with public offense be subjected before conviction to any more restraint than is necessary for his detention to answer the charge. So, in other words, none of this crap they're doing today. Oh, pretrial release. No, I'm not found guilty, which you can't impose any kind of a punishment on a man until after conviction. No person may be convicted of a public offense tried by indictment unless by the verdict of a jury, accepted and recorded by the court, or upon a plea of guilty, or upon judgment against him upon a demurrer to the indictment in the case mentioned in section 292. So we'll have to remember section 292. I don't think so. To answer your question on Facebook, Brenda, is what I'm going over why so many criminals are being released in California. No. So I get that they're not following it, but it's up to us to hold them accountable, folks. But you have to know this in order to know what they're doing is unlawful. Because how are you going to know what they're doing is unlawful if you don't know this and you don't know how to articulate this stuff? Let's see. Make sure you keep the peace required on. I'm looking for the one where it's talking about. Let's see here. Lawful resistance to the commission of a public offense may be made, first by the party about to be injured, second by other parties. That's right. We have the right to come to the aid and assistance of our fellow man um, at any time, right? Resistance sufficient to prevent the offense may be made by the party about to be injured, first, to prevent an offense against his person or his family or some member thereof. Second, to prevent an illegal attempt by force to take or injure property in his lawful possession. Any other person in aid or defense of the person about to be injured may make resistance sufficient to prevent the offense. Public offenses may be prevented by the intervention of the officers of justice. First, by requiring surety to keep the peace. Second, by forming a police in cities and towns and requiring their attendance to exposed places. But see, there again, that's erecting a multitude of offices, sending hither swarms of officers to harass our people and eat out our substance. We're not supposed to have standing armies. Remember, this is statutes, which in 1864 they thought that policy meant police. No, it's policy. Now, whenever the officers of justice are authorized to act in the prevention of public offenses, other persons who, by their command, act in their aid are justified in so doing. A complaint may be made before any of the magistrates mentioned in section 102 that a person has threatened to commit an offense against the person or property of another. Again, why is it talk about in the Civil Practice Act? Civil. Why does it talk? Why are we going in there for like breaches of the peace and um, assault and battery? But there's got to be a clear distinction here, or it's just a repeat of the civil. Doesn't make any sense. When the complaint is laid before the magistrate, he shall examine on oath. Now, notice that. Let's go with this. A complaint may be made before any of the magistrates mentioned in section 102 that a person is threatened to commit an offense against the person or property of another. Where does it say you got to go to the prosecuting attorney? Where does it say you got to go to the attorney general? When the complaint is laid before the magistrate, he shall examine on oath the complainant. That's right, complainant. Not plaintiff, complainant. And any witnesses he may produce, and shall take their depositions in writing and cause them to be subscribed by the parties making them. If it appear from the depositions that there is just reason to fear the commission of the offense threatened by the person so complained of, the magistrate shall issue a warrant directed generally to the sheriff of the county or any constable, marshal, or policeman in the territory, reciting the substance of the complaint and commanding the officer forthwith to arrest the person complained of and bring him before the magistrate. When the person complained of is brought before the magistrate, if the charge be controverted, the magistrate shall take testimony in relation thereto. See, this would be that initial appearance. The evidence must be reduced to writing and subscribed by the witnesses. If it appear that there is no just reason to fear the commission of the offense alleged to have been threatened, the person complained of shall be discharged. If, however, there be just reason to fear the commission of the offense, the person complained of may be required to enter into a bond in such sum not exceeding $5,000 as the magistrate. Oh man, that kind of limits bonds, don't it? As the magistrate may direct with one or more sufficient sureties to keep the peace toward the people of this territory. Now, wait, now you're using people instead of person? And particularly toward the complainant. The bond shall be valid and binding for 6 months, right to a speedy trial, 6 months. So from the date of the bond, you got 6 months to take this man to trial, or you violate his right to a speedy trial. And may upon renewal of the complaint, so if you renew the complaint, that's different, be extended for a longer period, or a new bond may be required. If the bond required by the last section be given, the party complained of shall be discharged. Doesn't say take him to jail. Doesn't say take him over there to jail and get some fingerprints and take his picture and do all that fancy stuff. Now, does it? Supposed to be taken before the nearest magistrate, lay the complaint, do the warrant, go seize the man, bring him back before the magistrate, and have this little hearing. Oh, and it gets better, by the way. Now, if the bond required by the last section be given, the party complainant shall be discharged. If he do not give it, the magistrate shall commit him to prison, specifying in the warrant the requirement to give security, the amount thereof, and the omission to give the same. I'll be darned. You cannot require to post bond or incarcerate until after an initial appearance. If the person complained of be committed for not giving the bond required, he may be discharged by any magistrate upon giving the same. A bond given is provided in this section 24, section 24, must be filed by the magistrate in the office of the clerk of the county. Any person, back to person here, who in the presence of the court or magistrate shall assault or threaten to assault another or to commit any offense against his person or property, or who shall contend. Now, see, that's not a public offense now, is it? With another with angry words may be ordered by the court or magistrate to give security, as is provided in section 24, or if he refuses to do so, may be committed as provided in section 25. The bond is to keep the peace. So a bond to keep the peace shall be deemed broken on a conviction of the person complained against of a breach of peace. Upon the attorneys producing evidence of such conviction to the court of the United States in the territory of Idaho, the court shall order the bond to be prosecuted, and the attorney shall thereupon commence an action on the same in the name of the people of this territory. Now, wait a minute. This is confusing. Upon the attorneys producing evidence of such conviction to the court of the United States in the territory of Idaho, the court shall order the bond to be prosecuted, and the attorney shall thereupon commence an action in the same. Okay, there's your public servant attorney that has to be licensed to practice law. The prosecuting attorney, he's a public servant, which I have found in here. In the action, the offense stated in the record of the conviction shall be alleged as a breach of the bond and shall be conclusive evidence thereof. No security to keep the peace or be of good behavior shall be required except as herein prescribed. So first they're saying you do, but then you don't. The mayor or other officer having the direction of the police in a city, town, or village shall order a force sufficient to keep the peace to attend any public meeting when he is satisfied that a breach of the peace is to be apprehended. Okay, well, why did you jump from no security to keep the peace or be of good behavior shall be required except as herein prescribed? Where is it? Anyways. When a sheriff or other public officer authorized to execute process shall find or have reason to apprehend that resistance will be made to the execution of his process, he may command as many male inhabitants of his county as he may think proper, and any military company or companies in the county, armed and equipped, to assist him in overcoming the resistance, and if necessary, in seizing, arresting, and confining the resistors and their aiders and abettors to be punished according to law, not according to bylaw. So the officers are certified to the court from which the process issued the names of the resistors and their aiders and abettors to the end of that they be proceeded against for the contempt of court. Every person commanded by a public officer to assist him in the execution of process, as provided in section 34, who shall without lawful cause refuse or neglect to obey the command shall be deemed guilty of a misdemeanor. If it appear to the governor that the power of any county is not sufficient to enable the sheriff to execute process delivered to him, he shall, on the application of the sheriff, order such military force from any other county or counties as shall be necessary. That says military. Why doesn't it say police force? Because they ain't supposed to be there. But hey, when 6 or more persons, whether armed or not, shall be unlawfully or riotously assembled, the sheriff of the county and his deputies, or the constables of the county and the justices of the peace, shall go among the persons so assembled, or as near to them as possible, and shall command them in the name of the people of the United States and the territory of Idaho, immediately to disperse. So let's go back to what happened on March 15th. They didn't do that because there was more than 6 people there. And they weren't armed, not that I could tell. But how that they weren't unlawfully assembled. Standing out in the general public. That's not unlawful. But when they allegedly come out with the warrant, this is what they should have done and said, hey, all right, guys, step back so we can make these arrests, to keep the peace among the people. If the persons assembled do not immediately disperse, the magistrates and officers shall arrest them, that they may be punished according to law, and for that purpose may command the aid of all persons present or within the county. If a person so commanded to aid the magistrate or officer neglect or refuse to do so, he shall be deemed guilty of a misdemeanor and shall be punished accordingly. If a magistrate or officer, having notice of an unlawful or riotous assembly, as provided in section 38, neglect to proceed to the place of assembly, or as near thereto as he can, with safety, and to exercise the authority with which he is invested for suppressing the misdemeanor. Now we go back, that was actually supposed to be done by an order of the court, right? In the execution of a process. If the person so assembled and commanded to disperse, do not immediately disperse, any magistrate or officer before mentioned may command the aid of sufficient number of persons and may proceed in such manner as his judgment is necessary to disperse the assembly and arrest the offenders. When an armed force is called out for the purpose of suppressing an unlawful riotous assembly or arresting the offenders, it shall obey such orders in relation thereto as may have been made by the governor or by a judge of the court of record or the sheriff of the county or by a magistrate mentioned as in section 38. So in other words, they're not even really supposed to be armed forces, right? Because that would be an indicator that the above, they're not supposed to be armed. I don't know. Yeah, that's what it says there. When an armed force is called out for the purpose of suppressing an unlawful or riotous assembly or arresting the offenders, it shall obey such orders in relation thereto, as may have been made by the governor or by a judge of the court of record or the sheriff of the county, or by a magistrate mentioned as in section 38. When there is an unlawful or riotous assembly with the intent to commit a felony or to offer violence to person or property or to resist by force the laws of the territory, and the fact is made to appear to the governor or to a judge of the district court or probate court or to the sheriff of the county, either of those officers may issue an order directed to the commanding officer of a division, brigade, or regiment, battalion, or company to order his command or any part thereof, describing the kind and number of troops, to appear at a time and place therein specified to aid the civil authorities in suppressing violence and enforcing the laws. So, see there again, supposed to be the military, not police. Nowhere in there does it mention police. And in fact, it should be the sheriff. The commanding officer to whom the order is given shall forthwith obey the same, and the troops so required shall appear at the time and place appointed, armed and equipped with ammunition as per inspection, and shall execute any order that they shall then and there receive according to law. When the governor shall be satisfied that the execution of civil or criminal process has been forcibly resisted in any county by bodies of men, or that combinations to resist the execution of process by force exist in any county, and that the power of the county has been exerted and has not been sufficient to enable the officer having the process to execute it, he may, on application of the officer or of the district attorney, there's that district attorney, or probate judge of the county by proclamation to be published in such papers as shall direct, declare the county to be in a state of insurrection, and may order into the service of the territory such number and description of volunteer or uniform companies or other militia of the territory as he shall deem necessary to serve for such term and under the command of such officer or officers as he shall direct. I don't see police in here. The governor may, when he shall think proper, revoke the proclamation authorizing by the last section, or declare that it shall cease at such time and in such manner as he shall direct. Any person who shall, after the publication of the proclamation authorized by this section 46, resist or aid in resisting the execution of process in any county so declared to be in a state of insurrection, or shall aid or attempt the rescue or escape of any person from lawful custody or confinement, who shall resist or aid in resisting any force, right? In other words, you're pretty much screwed if you're actively engaged in insurrection and the governor does a proclamation. Okay. Oh, what's this? Proceedings for removal of public officers. How appropriate under the Criminal Practice Act for public offenses. Now, any territorial officer created by territorial law shall be liable for impeachment for any misdemeanor in office. All impeachments shall be tried by the council. When sitting for that purpose, the councilman shall be upon oath or affirmation. So we talking about like city council? When a civil officer of the territory is impeached by the House of Representatives for a misdemeanor in office, the articles of impeachment shall be delivered to the president of the council. So no, that's got to go to the legislature. Council, because that's right there. House of Representatives. Council shall assign a day for hearing the impeachment and shall inform the House of Representatives thereof. President of the council shall cause a copy of the articles of impeachment with the notice to appear and answer the same at the time and place appointed, to be served on the defendant, not less than 10 days before the day fixed for the hearing. Service must be upon the defendant personally, or if he cannot, upon diligent inquiry, be found within the territory, the council, upon due proof of the fact, may order that publication be made in such manner as they deem proper of a notice requiring him to appear at a specified time and place and answer to the articles of impeachment. If the defendant did not appear, the council, upon proof of service of publication as provided in the last two sections, may of their own motion or for cause shown assign another day for hearing the impeachment, or may then, or at any other time which they may appoint, proceed in the absence of the defendant to trial and judgment. When the defendant fears he must answer the articles of impeachment, which he may do either by objecting to the sufficiency of the same or by the article therein, or by any denying the truth of the same. If the defendant object to the sufficiency of the impeachment, the objection must be in writing, but need not be in any specific form, it being sufficient in the present intelligibly the grounds of the objection. If he deny the truth of the impeachment, the denial may be oral or written oath, and shall be entered upon the journal. If an objection to the sufficiency of impeachment be not sustained by a majority of the members of the council who heard the argument, the defendant shall be ordered forthwith to answer the articles of impeachment. If he plead guilty or refuse to plead, the council shall render judgment of conviction against him. If he deny the matters charged, blah, 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 blah. So, kind of getting some mixed messages here about who is supposed to be impeached and who isn't. I don't know. Seems a little confusing here. Unless we're talking about the actual elected official, right? I guess that would actually be a civil officer of the territory. Yeah, it would have to be an elected official. I'm seeing this was stuff that I talked about before when Chris and I were doing this stuff. I'm like, dude, I think they're supposed to go through impeachment. At least elected officials are supposed to go through impeachment. Oh, what's that? If judgment or suspension be given, the defendant shall, during the continuance thereof, be disqualified receiving the salary, fees, or emoluments of the office. Yeah, we're talking elected officials. Whenever articles of impeachment against any officer subject to impeachment shall be presented to the president of the council, such officer shall be temporarily suspended from his office and shall not act in his official capacity until duly acquitted. Upon such suspension of any territorial officer created by territorial law, the governor shall immediately take charge of his office, and such office shall be once be temporarily filled by appointment by the governor, by and with the advice and consent of county. Yeah, this is definitely an elected officer, civil officer. So if the offense for which the defendant is impeached be the subject of an indictment, the indictment shall not be barred by the impeachment. So, an accusation in writing against any district, county, or township officer, for willful or corrupt misconduct in any office may be presented by the grand jury of the county for which the officer accused is elected or appointed. Bingo. Hmm. Hmm. The accusation shall state the offense charged in ordinary and concise language and without repetition. The accusation shall be delivered by the foreman of the grand jury to the district attorney of the county, who shall cause a copy thereof to be served upon the defendant, and require by notice in writing of not less than 10 days that he appear before the district court then sitting, or at the next term, and answer the accusation. The original accusation shall then be filed with the clerk of the district court. So why aren't our county prosecuting attorneys, district attorneys, not prosecuting public servants like they should be? The defendant must appear at the time appointed in the notice and answer the accusation unless for some sufficient cause the court assign another day for the purpose. If he does not appear, the court may proceed to hear the detriment, hear and determine the accusation in his absence. The defendant may answer the accusation or by objecting suspicion thereof, or by any article therein, or by denying the truth of the same. Same thing again. Seems a little confusing to me, but I can't imagine what it's like out there to people that haven't studied law like I have. If I'm getting confused here, how many other people out there are getting confused? Ah, hmm. Upon a conviction, the court shall immediately or within 5 days, as they may appoint, pronounce judgment that the defendant be removed from office. But to warrant a removal, the judgment must be entered upon the minutes assigning therein the cause of removal. Causes. From a judgment of removal, an appeal may be taken to the Supreme Court in the same manner as from a judgment in a civil action. But until such judgment be reversed, the defendant shall be suspended from his office. Pending the appeal, the office may be filed as in case of vacancy. Same proceedings may be had on like grounds for the removal of a district attorney, except that the accusation shall be delivered to the district judge of the district, who shall thereupon appoint someone to act as prosecuting officer in the matter, or shall place the accusation in the hands of the district attorney of an adjoining district and require him to conduct the proceedings. So that means the judge is supposed to do that if it's the actual prosecuting attorney in that county. It's awfully weird the way this is laid out. It doesn't say anything about the attorney general. Now, remember we read before, all these public offenses are misdemeanors at a bare minimum, and they all have to be by indictment. You got to have an indictment. No ifs, ands, or buts. Now, here we go. Every person, whether an inhabitant of this territory or any other state or county or of a territory or district of the United States, shall be liable to punishment by the laws of this territory for a public offense committed by him therein, except when it is by law common exclusively in the courts of the United States. So now this just brings everybody in under the Criminal Practice Act, doesn't it? I mean, that even says free inhabitant. So in 1864, we're recognizing that there are inhabitants Well, no. Yeah, I don't know. I think we're actually talking about territorial jurisdiction, but it still says person, not man, and it doesn't say free inhabitant. Okay, I see what it's getting at. When it's talking about United States stuff. Okay. The commission of a public offense commenced without this territory is consummated within the boundaries thereof. The defendant shall be liable to punishment, therefore, in this territory, though he were without the territory at the time of the commission of the offense charged. Right. Okay. Provided that he consummated the offense through the intervention of an innocent or guilty agent without this territory or any other means proceeding directly from himself. And in such case, the jurisdiction shall be in the county in which the offense is consummated. So there again, wherever the crime was committed, that's the county it has to be heard in. So you can't file something in a different state where an alleged crime happened in a different state in a different county. Field McConnell. So right. Yeah, and that's the key there, Amber, I hear on Facebook. It's a little bit confusing. It does make more sense than not, though, as long as you keep track of the correct words, paying close attention to people, person, and the specific language in regards to public and public servants. I have to agree. Okay. I mean, the first indicator is public and person. In propria persona, a man in his proper person acting as governor. So, see, okay, here we go. Here's some of them words, right? When an inhabitant or resident of this territory shall, by any previous appointment or engagement, fight a duel without the jurisdiction of this territory, and in such duel, a wound shall be inflicted upon any person, where if he shall die within this territory, the jurisdiction of the offense shall be in the county where the death shall happen. Okay. By any previous appointment or engagement, again, public servant, appointed in the position of public trust. Oh, wait, never mind. Let me reread that. When an inhabitant or resident of this territory shall, by any previous appointment or engagement, fight a duel without the jurisdiction. So what it's talking about is they had a previous appointment to fight or engagement to fight a duel outside of the jurisdiction of this territory. And in such duel, a wound shall be inflicted upon any person whereof he shall die within this territory. The jurisdiction of the offense shall be in the county where the death shall happen. Okay. I had to reread that to get that. So if you make an appointment to have a duel or an engagement to have a duel, and you take that fight outside the jurisdiction of this territory, and he dies over in a different one, where the jurisdiction is where he died. When a public offense is committed in part of one county and in part of another, or the acts or effects thereof constituting or requisite to the consummation of an offense occur in two or more counties, the jurisdiction shall be in either county. When a public offense is committed on the boundary of two or more counties or within 500 yards thereof, the jurisdiction shall be within either county. When an offense is committed within this territory on board a vessel navigating a river, bay, slough, or lake, um, or lying therein, in the prosecution of her voyage, the jurisdiction shall be in any county through which the vessel is navigated in the course of her voyage, or in the county where the voyage shall terminate. Where they get them, right? The jurisdiction of an indictment for the crime of forcibly stealing, taking or arresting any man, woman, or child in this territory and carrying him or her to another county, state, or territory, or forcibly taking or arresting any person or persons whomsoever with a design to take him or her out of this territory without having established a claim according to the laws of the United States. Ooh, according to the laws of the United States, or for hiring, persuading, enticing, decoying, or seducing by false promises, misrepresentations, and the like, any Negro, mulatto, Indian, or colored person to go out of this territory, or to be taken or removed therefrom for the purpose and with the intent to sell, right, to sell them into slavery or involuntary servitude, or otherwise to employ him or her for his or her own use, or to the use of another without the free will and consent of these people, shall be in any county in which the offense is committed, or into or out of which the person upon whom the offense was committed may, in the prosecution of the offense, have been brought. That shall be done by the offender in instigating, procuring, procuring. So, okay, this is 1864, people. Clearly, slavery was abolished in 1864. Hmm. Oh, okay. Well, I didn't find the one part that was yeah. Well, I'll look for it again on I know it's going to be right here coming up where it talks about the oh, here it is right here. That's it. So we'll save that for Monday Night Law. Okay. Oh, wait. That was the first legislative session for the territory of Idaho, which was before they made the Constitution. So we had the Organic Act of the Territory of Idaho in 1863. They assembled in, I want to say it was like October or November of 1863 and concluded in like January or February. Um, right? Sorry, Rob. What a tease. Bring it back for Monday. It'll be a good one. So that was the first legislative session of the Territory of Idaho, 1863, 1864, which includes the Organic Act of the Territory of Idaho. It includes the Constitution of the United States of America, which shows the Bill of Rights as articles. Article 1, Article 2, Article 3, you know, it shows all of the articles, not amendments. So, um, somebody's got some explaining to do why we're calling them amendments. Sorry, I'm tired. Been a long day and pretty hot, warm day today. So anyway, for those of you, I did talk about Field McConnell. Yes, that he's at home enjoying his home, and um, uh, following what he's supposed to follow there. House arrest, ankle monitor, whatever. He is allowed to have a non internet based phone, smartphone, or anything like that. So, anyways, Organic Act of 1863 was first, then the count. Nope, nope. Actually, the Organic Act was first in 1863. Then we had 17 legislative sessions creating all these statutes. Then we did the Constitution. Our Constitution wasn't ratified by the people until 1890. So, and reading that other one that I read from Monday was talking about how you can't make changes to the Constitution or the laws except for by and through the same uh, means or process that you use to create them. Okay, that means those were the statutes that were created before the Constitution, which was done in a convention, which literally means they would have to go into a convention to even alter a statute or the Constitution, which is what I've said before. You cannot make amendments to the Constitution except by and through a convention. Yes, that's absolutely correct, Amber. 17 legislative sessions to create all these acts of the legislature. Then they did the Constitution. In 1889, the Legislative Assembly ratified or passed their Constitution, which had to go to who? Congress. Then Congress approved it, then went back down to the people and approved by the people. So, again, if you'd like to help support what I've got going on, especially at the office or the channels here, you can send through the snail mail over here to the current office. Hopefully, I can get enough money together to get in there July 1st. Like I said, I'm about halfway there. So, if you can help out, I would greatly appreciate it. Help us get into that building. It's going to be quite amazing if I can get into that building. So, address 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. And again, I want to thank everybody that's been giving support, and especially those over there on Patreon. We're having some pretty good meetings on Wednesday night workshop, and I want to get into this building so I can get set up, audio, video, and all that, and hold classes at my own building, and I'll record them and obviously upload them to Patreon. The ultimate goal here was to, or one of the ultimate goals was to do a school. So this gets me closer to achieving that goal. I'm sure as time goes on, 40 seats are not going to be enough for school. So thank you, Amber. And comment is, your Patreon rocks. Everyone should join. And still trying to figure out what to do and find the time to do it, to get on, get my restream and all that stuff. Recommended by some people there at the Wednesday night workshop for Patreon. A couple different places I need to get signed up to in case things go down, which This is the nice thing about Wednesday night workshop, because I do get to talk about all those things that I'm not supposed to be able to talk about on Facebook or YouTube. So, well, that's great, Brenda, but that doesn't do me any good here in Boise, Idaho. Maybe for a law seminar down there, yeah, like a one-time event or annual event or something like that, or a reoccurring event maybe. But I live here, so a little bit difficult to travel to the office down there. But I have keep that in mind, Brenda. I will. So, all right, folks, it's the weekend. I hope everybody has a good, fruitful, fun weekend. Stay out of trouble. At least don't go looking for it. But um, where you been at, Jacqueline? I didn't even see you on Wednesday night workshop the last couple of weeks, or maybe I just missed you. I don't know. But apologize for the yawns. I am tired. I'm beat. Been a long day. So much love to everybody out there. Thank you all for being here. Way to go, American Patriots. Thank you for being here. Much love, everybody. Have a wonderful night, and we'll see you for Monday Night Law. All right. Good night, everybody.